I'm going to talk about disclosure and the IBA rules on the taking of evidence in international arbitration. It is hard to imagine justice to be served without a certain degree of transparency in the proceedings. And that is exactly what the disclosure is all about: transparency. Disclosure differs substantially from one arbitration to another, but a representative international approach is generally based on the IBA rules on taking of evidence in international arbitration. There are different disclosure mechanisms available in international arbitration, but in this presentation I will focus on documents disclosure as the most common and significant mode of disclosure, also the one that is regulated in detail by the IBA rules. I will address four basic points. First, when is appropriate to have documents disclosure? Second, what is the procedure for documents disclosure under the IBA rules? Third, what happens with the documents disclosed in the course of arbitration? Are they protected by the duty of confidentiality? And finally, what happens if the party fails to comply with the tribunal's order to disclose certain documents? Starting with my first point, when is appropriate to have documents disclosure? In cases where one party only has access to certain essential factual materials, such as, for example, the profitability of a business in a post-M&A dispute, disclosure may be particularly appropriate. On the other hand, where a party seeks to conduct a fishing expedition into the files of the opposing side in order to challenge, for example, a witness's credibility or experience, discovery will usually be inappropriate. Coming to my second point, what is the procedure of document production under the IBA rules? First, each party discloses in advance in its statement of case or statement of defense all of the documents on which it intends to rely in support of its case. Thereafter, each party will be permitted to request an identified document or a narrow and specific category of documents to be disclosed by the opposing side. The parties' document requests are required to specify how the documents requested are relevant to the case and material to its outcome. So it is not enough to be material for a disputed issue only, but the document must be relevant for the outcome of the entire case. Parties are also requested to state that the document is not in their own custody, meaning that disclosure is only available for documents that the party does not possess. It is not available for the document that a party already possesses. Documents are generally subject to production only if they are within the possession, custody, or control of the opposing party. After disclosure requests are made, the parties respond to the requests either by producing the requested documents or setting forth the reasons for refusing to do so, including objections on grounds of immateriality, insufficient specification, privilege, or burdensomeness. If there is no voluntary compliance with the discovery request, an application can be made to the tribunal, and the tribunal will make an order either by denying or granting the parties' requests, often narrowing or rephrasing requests which are granted. Finally, there is no oral hearing for documents for disputed disclosure issues under the IBA rules. Coming to my third point, what happens with the documents disclosed? Are they protected by the duty of confidentiality? Straightforward answer is, of course, yes. The IBA rules provide that any document submitted or produced by a party or non-party in the arbitration and not otherwise in the public domain shall be kept confidential by the arbitral tribunal and by the parties, and shall be used only in connection with the arbitration. there are certain, of course, exceptions to this general rule. Coming to my fourth and final point, what if the party fails to comply with an order to disclose documents? The IBA rules provide arbitrators with the power to draw adverse inferences, meaning that the tribunal may conclude that undisclosed document would be adverse to the interests of that party. This is exactly how we cherish transparency that I mentioned in the beginning as a key value behind the disclosure in international arbitration.